the position of Justice Warsame on robbery with violence, on the question of death sentence. According to Justice Warsame, offenses under Section 292(2), if you are convicted, death sentence. Welcome to Court Helicopter trending videos and trending stories. We are still on Justice Warsame, who has been promoted to the Supreme Court. Justice Warsame has proved that he is a man of wit, a man of integrity, and a man who can stand on his ground. The JC said that he is a man who has developed the law. He is a man who has had a lot of jurisprudence on the law. Let us look at Justice Warsame. Everybody knows Teacher Albert Ojwang. Teacher Albert Ojwang was murdered at Central Police Station, inside the cells, and the country was almost burning. Among the people arrested were the Chief Inspector, the OCS of Central Police Station, and other police officers. It was a very unfortunate issue. So has this question ever been brought before Justice Warsame? Yes. Justice Warsame has faced a similar issue, and that one is already decided. A Chief Inspector of Police, OCS Ruaraka, one Chief Inspector Nahashon Mutua, was convicted of having beaten a prisoner, a person who was arrested and taken to the police station at Ruaraka police station. That person died. And when he died, surprisingly, the police under Mutua decided to fake another person, a prisoner who was inside the police cells. That person, called Kevin, was arrested and charged for murdering this person. Later evidence came out when IPOA took up the matter that it is not Kevin who murdered. It is actually the OCS himself. The trial went. The OCS gave his story. That is Chief Inspector Mutua. And he was convicted. He appealed before Justice Warsame. And what did Justice Warsame do? This now is a landmark ruling, a landmark judgment, similar to the murder of Albert Ojwang. This is Nahashon Mutua, appellant versus the Republic in Criminal Appeal number 55 of 2019. The quorum was Okwengu, Justice Warsame, then Judge of the Court of Appeal, and Justice Murgor. It goes like this. Arising from complaints made to the Independent Policing Oversight Authority, IPOA, investigations were carried out and the charge against the suspect was withdrawn, and Chief Inspector Nahashon Mutua, who was the material time the officer commanding the station at Ruaraka police station, was arrested and arraigned before the High Court and charged with the murder of Martin. The proverbial table had been turned, the hunter had become the hunted. The proverbial table had turned. The hunter, the police, became the hunted. The trial resulted in Mutua being convicted and sentenced to death. Mutua appealed this decision to the Court of Appeal. The fact of the matter is that the events leading to the trial in the High Court commenced on 19th December 2013, when Martin, who is now deceased, arrived in his house at around 9:30 p.m. His wife, Penina, who was a housewife watching TV, they quarreled over their child. Out of that quarrel, Penina took a complaint to the police. The police came and arrested Martin. When Martin came in, he was taken to the police and booked inside. In the evidence that we see being given, when Martin was inside the police cells, Chief Inspector, OCS, was seen beating heavily Martin with a blunt object on his head. Two people say after he beat up this person, inmates saw the OCS beat one, or that is Martin. In paragraph 18, following complaints made by Victor and Karimi to the police IPOA, investigator Okeyo, a principal investigator with IPOA, was assigned to investigate and determine the circumstances under which Martin died. Okeyo visited Ruaraka police station and interviewed several witnesses, including the officers who were on duty on the night. He also interviewed some of the suspects who were in the cells. The suspects implicated Mutua, the OCS, as the person who assaulted Martin and Victor. IPOA wrote to the DPP asking him to hold the criminal prosecution that had already been initiated against Kevin for the murder of Martin, and the DPP entered a nolle prosequi in the criminal case. As a result of his investigations, Okeyo concluded that Martin was assaulted and seriously injured by Mutua, and that in an attempt to cover up, a robbery suspect who was in the cells with Martin was assaulted and grievously injured by Mutua. In the attempt to cover up, a robbery suspect who was in the cells with Martin was blamed. He also visited Nairobi Hospital and found that Martin was left at the hospital without any security, even though he was under police custody at the time he was taken to hospital. IPOA submitted their investigations report to the DPP, who agreed with their recommendation that Mutua should be charged with the murder of Martin. This is what the judge found out. After full trial and following submissions made by the prosecution and counsel for the defense, the trial court delivered a judgment in which it found that Martin died as a result of injuries sustained from an assault that he suffered while at Ruaraka police station. Upon reviewing the evidence adduced by the prosecution and the defense, the trial judge found out that Martin was taken to the police station before Victor, but Victor was placed in the cells before Martin, that there were a few inconsistencies and all those things. The judge visited the trial. The judge visited the police station, and this is what the judge said. The trial judge also found that Mutua and officers under his command flouted police procedures. The officers did not keep a tight check on suspects, some of whom were said to be drunk and disorderly. That although it was said that prisoners fought in the cells, there was no officer to testify regarding this. So the judge, after visiting there, found out that indeed it is the OCS who was involved in the murder. What did the judge say? He said, in regard to the malice aforethought, the trial judge, relying on Bonaya, IPOA, and Republic, found that the injuries suffered by Martin, which included severe injuries on the head, neck, face, broken ribs on the right side, 5 broken ribs on the left side, and bleeding on the brain, were a clear indication that Mutua struck Martin several times forcibly, and that Mutua, being a senior police officer, knew or ought to have known that such repeated assault of Martin by a metal bar on sensitive area would cause death or grievous harm. After concluding that malice aforethought in terms of section 206 of the Penal Code was established, the trial judge convicted Mutua, OCS, Chief Inspector, the offense of murder and sentenced him to death. Mutua was dissatisfied with this judgment. He raised 22 grounds of appeal, and this appeal appeared before Justice Warsame. Mutua was represented by Dr. Hamino. In paragraph 41, during the hearing of the appeal, Mutua was represented by Dr. Hamino, Mr. Gashie Mwanza, and MS Brenda Wekesa, while the respondent was represented by Gitonga Muriuki. In his highlighting of the submissions, Hamino pointed out that there was violation of Mutua's constitutional and human rights, as there were no effective criminal investigations carried out before Mutua was brought to court. Dr. Hamino argued that a decision having been made to prosecute Kevin Odhiambo with the murder of Martin under section 26 of IPOA, then IPOA had no jurisdiction to investigate the matter further, that IPOA exercised authority without the sanction of the DPP, and that the prosecution of Mutua on the statements taken by IPOA rendered his trial irregular. Dr. Hamino also submitted that it was wrong for the learned judge to visit the scene of crime and turn the court into a witness institution. Justice of the judge Warsame, after evaluating this, he went on in paragraph 49 to say, it is clear that the incident occurred at the police station at night. The only person who were at the station at that time were the suspects who were in the cells and the police officers who were on duty. 3 of the suspects, Ali, Ram and Tom, who testified for the prosecution, each swore that they saw Mutua assaulting Martin. Another suspect was Njia, who testified as a defense witness. He swore that Martin sustained his injuries in the cells when a fight broke out after he resisted his pockets being ransacked by Kevin, one of the suspects of the cells. Njia explained that Kevin beat up Martin, hitting his head against the wall. You remember the first explanation the IG and DIG gave is that Ojwang hit his head on the wall. And by morning, Martin was unconscious and unable to stand. Warsame moves on to say, the police officers who were on duty that night included 2 prosecution witnesses, Mukari and the others. According to Warsame and team, this is not true, and they went ahead and dismissed the defense. Warsame's argument is, it is inconceivable that 2 suspects could have sustained such serious injuries in the cells just next to the report office without the police officers who were charged with the responsibility of taking care of the prisoners intervening and getting to the bottom of the matter. We do not find the evidence of PC Kennedy, that is Police Constable Kennedy, to be of much help in this regard. No such report was filed or found in the OB or nothing, and therefore they dismissed that argument. Justice Warsame, in paragraph 53 brought out the famous Blue Code of silence. It is a famous thing that the police officers will never implicate their bosses or another police officer. What does the judge say? The Blue Code of silence is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. It is the unwritten rule according to which police officers never provide incriminating information about their colleagues, to close ranks in silence, and to cover up knowledge of a fellow officer's wrongdoing with a collective blanket of self-preservation. A feeling of a spirit decouples among officers who by and large depend on each other for their every risk lives as they confront the violent and hostile world of policing and crime. Justice Warsame is saying, whenever the police have evidence against another police officer involved in the crime, my friend, the police officers will never give evidence. They have taken an oath called the Blue Code of silence. They will keep quiet. Remember the Pepibendo matter in Kisumu. Remember all the matters. The police will never give evidence incriminating another police officer. The judge goes on. The judges proceeded and said, further, we agree with the trial judge that the conduct of Mutua in regard to the victor raised a red flag. Why would such a senior police officer go out of his way to visit a suspect in hospital? Mutua went to visit Martin in hospital. He paid his medical bill. He drove him to his house. The explanation can only be testified, can be as testified to be by Victor that Mutua was the one who had inflicted the injuries upon him, and the evidence of Jackson that Mutua was trying to prevail upon Victor not to pursue the matter. Victor explained the frustrations that he went through in his effort to secure justice for Mutua's malfeasance. There is no reason why Victor would have relentlessly pursued the allegations against Mutua if they were untrue, particularly after Mutua had gone out of his way to assist him pay the hospital bill. The allegations that Victor was trying to extort money from Mutua as inducement to drop his complaint cannot be true. The investigations by IPOA mainly concerned the death of Martin, and once initiated, the matter was no longer in Victor's hands, as he was not in a position to influence the statements of other witnesses. Final, the judges said they were convinced that the cause of murder was Chief Inspector Mutua who beat up this person, Martin, in the cells. Mutua challenged the sentence of death sentence. What does the judge Warsame say? Justice Ano Kwengo, Justice Warsame, and Justice Murgor said, as regards the appeal against the sentence, the trial judge gave a considered ruling, taking into account Mutua's mitigation, and gave reasons why she considered the sentence of the death appropriate. Warsame and team said, and this is where some of these decisions is what took Warsame to the Supreme Court. This sentence imposed by the trial judge is a legal sentence and cannot be said to be excessive. Why? Warsame on the killer punch, he he says, taking into account the circumstances and impunity of the police on how the offense was committed, the impunity, the cruel torture, the beatings of Ojwang Albert, the beatings of this Mutua, the beating by Mutua of this man. The judges, led by Warsame, said, we find no reason. Pole Mutua. We find no reason to interfere with the discretion of the trial judge. The appeal is therefore dismissed in its entirety. So Justice Warsame already dealt with the Ojwang matter. Similar facts. Will this be the decision that is likely to be used by the judges trying the case of the murder of Justice or of Ojwang? Already this is a decision of the Court of Appeal. This decision binds the High Court. Warsame dismissed the appeal for the sentence of death sentence. This is not the only case Warsame dismissed. In the second case, Criminal Appeal number E009 of 2023, Justice Warsame, Justice J.M. Mativo, and Justice Gashoka in December 11, 2025, while he's sitting in Nakuru. This is an appeal that went to the Court of Appeal. What are the facts? The appellant submits that the sentence of death imposed by the trial court and confirmed by the High Court was not only harsh but unconstitutional. He relies principally on the decision of the Supreme Court of Francis Karioko Muruatetu and another versus the Republic. He says death sentence is unconstitutional, it is illegal, it is not the right sentence to give. What does Justice Warsame and his team say? It has been argued in justifying this state of affairs that by paragraph 48 of the judgment in this matter, or indeed the spirit of the judgment as a whole, the court has outlawed all mandatory and minimum sentence provisions, and that although Muruatetu specifically dealt with the mandatory death sentence in respect of murder, the decision is expansive reasoning can be applied to other offenses that prescribe mandatory minimum sentence. What did the judge and Justice Warsame's position were? Paragraph 11. Justice Warsame said, and that is Justice Mativo, Gashoka, and Warsame, the implication of this clarification directly disposes the present appeal. The mandatory death sentence for robbery with violence under section 296(2) remain valid, and there is no legal basis for this court to interfere with the sentence imposed. In paragraph 12, in the result, we find no merit in this appeal. The appeal against sentence is hereby dismissed. The sentence of death imposed by the trial court on 10th of February 2012 and confirmed by the High Court on November 6th, 2015 is hereby affirmed. So when you look the position of Justice Warsame on robbery with violence, on the question of death sentence, according to Justice Warsame, offenses under section 292(2) If you are convicted, death sentence. What are these sentences? Stealing a phone, stealing a biro pen, stealing a laptop, robbing somebody. Remember, robbery with violence is for you to be two. You don't need to be armed. If you rob at night, remember, that is robbery with violence. Justice Warsame has told you death sentence is the only thing that you are waiting. A steadfast judge, a person with the fidelity of the law. Justice Warsame now, a Supreme Court judge. All the best in your new job. From Court Helicopter News, it is Wakili Dan Stanomari.